Good afternoon. Welcome to a meeting of the Regulation Subcommittee of the California Paraprofessional Program Working Group. I will take roll. Hardston.
Here.
Kirkmeyer has advised us that she will not be present. Sarush.
Here.
Thank you. We have a quorum. And I know Leah needs to leave early and she's going to lead us off on the discussion about proactive regulation. So I'll go ahead and hand it to you. And as we discussed, I'm going to share the slideshow that we used last time.
Linda, should we do public comment?
Oh,
Yes.
I'm sorry. Yes, I apologize. Let me see if we have any public comment. We have 4 attendees. Is there anyone who'd like to make public comment? You can raise your hand in Zoom. I think everybody knows that by now. I don't see any raised hands. So shall I go ahead and share this?
As Linda mentioned, I have to leave at 2, unfortunately. So I thought I could kick off the proactive regulation discussion. Linda sent out the information about reflecting our current thinking on program evaluation, but I wanted to start off just reminding you of your task, which is to come up with recommendations for proactive regulatory measures that will be implemented. And these are just the slides we went through at the last time we discussed this issue. So here's the key risks that you all had identified. And then if you could go forward, Linda. And here are the things, the activities or requirements or resources that you determined might be responsive to those risks that have been identified. And where we left things off the last time was, I think it was you in particular, Amos, felt that it was going to be difficult to settle on any one of these initiatives or more than one of them without having an understanding of the evaluation framework and the potential interplay between what would be required of licensees under the evaluation paradigm versus what we might require of them vis-a-vis proactive regulation. So these, I think, this is our universe of options on the regulatory front at this point. And now, Linda, maybe we can put up the table that you created. Okay. So this is, of course, just our initial staff take. And we tried to benchmark this to or crosswalk it with the National Center for State Courts structure, because I think it would be quite valuable to be able to make interstate comparisons to the extent possible. So I think I'll just pause there. This is what we've done. I think you can see what we're thinking in terms of data that would be collected for program evaluation versus regulation purposes, and how that might impact your decisions around what would be the regulatory requirements. There is, for example, no self-assessment on this chart because the self-assessment is not contemplated as part of the program evaluation model. So Amos, I think you in particular asked for this. Did you find this helpful? Does it help you to better understand what you might want to require of licensees on the regulatory front?
Yeah, I think my position is the same as it was before. This is very interesting. I would like to talk more about the evaluation, but focusing on the proactive regulation, my view is that we should include the things that are supportive for competency. So MCLE, ethics hotline, toolkits, and things like that, but we should not be doing the self-assessments or the case review. Need to think more about the client surveys because I think that could be very helpful. I just don't fully understand who would be doing that and who would be getting the results. But I do think the evaluation is critical. I don't know that we're the right committee to be focused on this, and my view is it should be an independent evaluation. I do think it is going to be quite burdensome on licensees, especially the case outcomes and client satisfaction. But evaluations are always very burdensome. So that is a continued concern as well.
Okay. So with respect to finalization of the evaluation methodology, I think that is certainly beyond the scope of this working group. And however, a recommendation that the evaluation be done by an independent entity is perfectly within scope of the working group. And I think nobody's going to disagree with you. Even if the state bar wanted to, we don't have the capacity to do that kind of evaluation. What I am hoping the full working group will take up are the metrics, because I would like to be able to say to the board, these are the recommended metrics that should be included in any evaluation design, so that when there's an RFP, for example, for an evaluator, there are at least some bullet points of these are the data elements that need to be at a minimum captured. So that's evaluation. For regulation, the recommendation will be coming from this group. And it sounds like you're taking self-assessment off the table. Would you find it helpful if we went back to the slide with the various regulation options? Or do you want to have this table up? Amos or Fariba?
The other slide is great for me. Of course, I'm only one vote on this, so other people might have other views, but and there used to be, I think I sent around an email long time ago. We discussed sort of a bullet point list of options, but if that slide is what's left, if you could go back to that slide.
Amos, why did you say you wanted to take self-evaluation off the table?
So that's been my consistent position. I think it seems like staff might keep including it, so there might be some interest in continuing to discuss it, which is totally understandable. But even from the beginning, my concern is self-assessments are going to be burdensome, and it's not clear how they will be used. If they're being turned into the bar, a self-assessment in the toolkit or a self-assessment as part of an MCLE program obviously would be fine. But I think this is being considered as potential for discipline or negative action that's being turned into the bar. Mm-hmm. And in connection with an evaluation that's going on at the same time, that is going to be burdensome in terms of the requirements on the paraprofessional. So it's mostly, the burden and the purpose. I think it would be great if self-assessment was created in terms of a self-assessment tool that could be included in the toolbox or used as part of an MCLE. I just think requiring it gives me concerns about the burden and the potential use and how effective that is. And it might really be an empty, it might look like we're regulating, but it really may not be effective and too burdensome. So that's what I explained before, and I still feel that way.
Mm-hmm.
Linda, I'm not sure what you're trying to show on the screen. At least for me, I'm not a really weird view.
It's showing the PowerPoint, not the full slide, but the action slide from PowerPoint when you go full screen. So, and you're on mute, Linda.
Let me try again. Sorry.
So
Okay.
proactive regulation to the extent the MCLE and ethics hotline and toolkits, I would be in favor of all, and any other supportive ideas that could help paraprofessionals provide competent services. I'd be very supportive of that.
Is self-assessment being used the right way here? I mean, to me, self-assessment is about critiquing one's performance and one's practice, and have I checked all the boxes? Have I done everything I will have to do? And then on the other slide that you just had, the table, perhaps self-assessment will help with whether the practice is viable, you know, with all the restrictions and all the requirements, whether the paraprofessional is able to make money sufficient enough to pay their expenses and actually sort to stay in the business. So I'm not sure in what context is self-assessment being used. That's why I'm a little confused here about the purpose of a self-assessment.
Yeah, so, and Freeba, I would agree with you. I mean, I think it's important for us all to do self-assessment. So I think if we created some kind of tool or self-assessment that people could use on their own, I think that would be great. I think what's being proposed is part of a regulation and discipline as mandatory self-assessments that get turned in to the bar for evaluation and potential discipline or potential action. And that's what I'm opposing.
And Leah,
So I
asking
don't- I
for
don't-
what? Asking
don't-
for what?
Yeah, I don't know if that's exactly true. So in attachment B of the agenda item for today, Linda gave, some examples of where self-assessments are in place. So we have like Colorado, Illinois, Wyoming, and then 2 from Canada. A couple of these are mandatory. 3 of them are mandatory. 2 of the 3 under certain circumstances. Some are confidential, some are not confidential. And so all of those are decision points to make, as well as the fact that it would not need to result in a disciplinary remedy. Another option could be an administrative remedy. An administrative suspension is an option, like what happens to you if you don't comply with MCLE. There even could be a fine. So I think that all of that is totally up for conversation. And I'm not sure, that staff is pushing it. I would say on the attorney side, a self-assessment is coming. It's not going to be mandatory at this juncture, but it is kind of coming. And there are many instances beyond those in this chart of self-assessments being implemented as part of the overall framework for either regulation and support professional development, or simply one or the other. So that's all I would just say there. You could construct this any way you wanted to, if you wanted to include it as a part of the regulatory framework.
So my view, again, is if it's not mandatory, and I don't know exactly what you're planning for attorneys, it might be that when the bar rolls it out for attorneys, it could roll it out for paraprofessionals at the same time. I don't know what the timing on that is, but yeah, my concern is, as I described, it being mandatory and turned into the bar and could lead to negative action. That's going to be very burdensome on the new profession. And I think we have to consider the evaluation burden as well.
Okay. Arifa, do you have any? In the agenda item, also Linda's provided these self-assessments, so you can see some examples of what they are. They look like.
To the extent there is an example of an optional one as a tool that people can use, I'd be totally supportive of that as part of the toolkit, or as part of a required or not required MCLE or optional MCLE that people could take.
And clearly I haven't had a chance, my apologies, to review the materials, but is there has there been an opportunity for these other states to comment on how valuable this self-assessment tool has been in their jurisdictions? and the quality of the responses?
We have heard several times, we being the California State Bar from Illinois, and you can see in Illinois, this is mandatory for attorneys who are uninsured. It is incentivizing attorneys to get malpractice insurance, and they feel that it's quite effective. So I know we've heard that. I don't, other than that anecdotal information, I don't know. And in Ontario, I have talked to them a number of times, and they have a pretty comprehensive, quote unquote, proactive regulatory framework, of which this assessment is part of that. And they believe that it is very effective, and they follow up on information that they receive.
In what way is it effective? Do you have any details? Sorry to bombard you with questions, but I'm just trying to figure this out. In what way is it effective?
So in Illinois, the efficacy is trying to increase the number of people who are getting professional liability insurance. Okay, so one is to disincentivize you from continuing to not be insured.
Okay.
So that's an easy metric. Like, are we seeing the insurance rates go up? And the other is it's a tool for making sure that people are forced to go through their obligations if they're choosing not to be insured. So that's effectiveness. In Ontario, I mean, I'm not, my recollection is not totally refreshed here, but based on information that they receive in these assessments, they will go in and contact the providers and provide them with support guidance. It's not used for discipline to my knowledge, but they will sort of go in and say, it looks like you need some help.
Okay. And has there been any information on the veracity of the responses? And you know, I just don't see how the state bar is even going to check into that. And not I'm saying these are bad people or I'm expecting them to lie or anything like that, but for a tool to be effective, the answers have to be true, right? It's a self-assessment, so.
Yeah, I mean, I guess it depends. Again, is it an educational tool? Is it forcing you to go through an exercise more than just reading the rules? But like you're going through this checklist or this set of questions that captures those rules in a practical way as it applies to these different elements of your practice, and you're having to say yes or no. If there's no potential for discipline associated with what your answers are versus completing or not completing the self-assessment, right? If it's not even discoverable, like you can see that in Illinois, I don't know, I would hope that would lead people to tell the truth. But I don't know, Fariba.
Right. Still want to create more work. You know, I want to balance that with the usefulness of such a tool. And
so a checklist could be very useful, right? I mean, again, it's a new profession and there are complicated rules. So I think a toolbox with, you know, information, education, checklists, self-assessments, I would be in support of all of that.
mm-hmm. But as long as you're saying, as long as it's not tied to disciplinary.
Right, as long as it's voluntary and not tied to discipline. So as a supportive tools.
I just think, but having heard all the, you know, their talk just now is, so you have to make it mandatory and you have to make it tied to some disciplinary rule to get responses. Otherwise, you know, it's just going to be in the toolbox gathering dust, you know, because there's a lot of work and these, you know, folks want to make money, keep generating income, and they don't have time to slow down and actually take a critical look at their practice. Am I following all the guidelines? Am I doing best practices? I think tying it to disciplinary rules will motivate them to actually use it as a tool and then improve their practice, right? Quality of their practice. At the same time, is that your responsibility? Do you want to make that the state bar's responsibility? So if you're rolling out one for attorneys, that means you want to make it the state bar's responsibility to make sure attorneys do this self-check and make sure that they are following the rules and so on and so forth, right?
But in
And
the initial rollout, the attorney self-assessment is not going to be mandatory. There's been some discussion of making it mandatory whenever somebody changes their practice status to solo, or maybe even small firm, because the concern or the observation is that a lot of people get in trouble when they've worked in a larger organizational setting, be it a government law practice or private law practice, where they haven't had to, for example, manage client trust accounts, and then they go off on their own in solo status, and that's when people get into trouble. So there's been conversation at some point about making the assessment mandatory at that juncture. But in the initial implementation stage, it's voluntary. And I'm thinking about two things. One, the Wyoming example that's in the packet, it begins at page 97, at least in my PDF. That's called a self-audit checklist. That's voluntary. And it is just a bunch of like yes or no questions. So it's and it's pretty short. And then Amos, I think you raised the idea of having this be eligible for MCLE. I guess it'd be like MCLE self-study. That might be one way to incentivize it for EBA without tying it to any like disciplinary or negative consequences, failure to complete, but instead trying to incentivize completion.
Yeah, I think something that is designed to help competency, like a self-assessment or checklist, could definitely be done with MCLE credit. Again, it could be part of a class, more of traditional presentation to walk people through it, or it could be a self-study, but I think it's a useful tool.
I like the questions a lot.
Yeah, it's really simple, this one. And I think that the one we're building for attorneys is going to be all online and interactive. So I think you'll be able to do things like a simple yes, no, but you can also drill down into the rules, which is something we could develop, because this Wyoming one is, doesn't clearly tie to the rules.
Okay.
So it sounds, Fariba, are you leaning in Amos's direction, meaning no mandatory self-assessment?
Actually, I just don't know if you don't make it mandatory, how many people would actually use it as a tool. And having kind of listened again to the conversation today and kind of taking a look at this, it's a really helpful tool for paraprofessionals, especially when it comes to questions having to do with their response to their client and their client satisfaction.
Yeah. And I'm trying to, I just want to say one thing. I'm trying to pull up my notes from our conversation with Stacy Butler, I think was her name, from University of Arizona Law School. Her recommendation to us, if you'll recall, was that the self-assessment be done not every year. I don't know when I'm going to find these notes. She had it something like, maybe it was every year for the first 3 years.
Right, something like that, gradual.
And then it phases out, and then it's only required in response to a triggering event.
Right, yes, I remember.
That's another option. And the last thing I'll say, because I have to go to Amos, is perhaps you also might want to consider not having this kick in during the evaluation data collection period, because there will be so many other ways of assessing competency during that period. Maybe you have it kick in after that ends. So sorry, Amos, I think wanted to say something.
I think that if it's somehow tied to a triggering event and we figure out a way to allow consumers complaints to be easily lodged and become a triggering event. I like that we don't just require this every so often, that we tie it to a triggering event. Especially since during the evaluation period. How long is the evaluation period?
I don't think we discussed it.
Okay, so anyway.
2 or 3 years, yeah.
Okay, so after that, be tied to a triggering event. Again, as long as, we haven't discussed that yet, but as long as there's an easy way for consumers to complain and for us to collect that information directly from the consumers, because I think it's going to be hard. What do you think about that, Amos?
I mean, do you mean as part of a disciplinary remedy, or do you mean just the bar separate from a formal disciplinary system? The bar can make mandatory requests of paraprofessionals when they decide they've gotten some complaints.
I was talking more about it'd be, I suppose, part of progressive discipline, right? A complaint is filed. This is maybe a first step or one of the steps.
Yeah, I have no problem if self-assessments or other things are included in sort of the disciplinary system. I think that's fine.
I'm sending you an email, Linda, because I found my notes from our conversation with Stacy on my other computer, not my State Bar computer. So I sent you an email to maybe put that up. This is, what she was recommending for the self-assessments. Basically, while Linda's looking for that, after the first and third years of practice only. And the subsequent self-assessments would be, you can read that there, based on a triggering event. And the idea is these would be required then, because this, under her approach, the State Bar is actually looking at what the self-assessments tell us in order to develop things like new MCLE content, new tools for the toolkit, to sort of use the information to tell us what kind of professional development and support paraprofessionals need.
And is State Bar committing those? I mean, is the plan that the State Bar commit those resources for something like this?
No, this is what she recommended to us with respect to the paraprofessionals.
Right.
Yeah. Well, if you recommend it, that's what would go to the board. And if it's ultimately in the program design, it would have to be funded. Yeah.
Yeah, I would be very in favor of something like that through surveys that the bar, I think, does sometimes with attorneys, but not through mandatory self-assessments.
Yeah, this is Randy. When
Good. Hi. Yes.
When OPC staff was researching the types of self-assessment formats, we did interview a couple of the other states. We have some feedback from Colorado and from Illinois. Illinois was the mandatory program, and the feedback we got from their program administrator was that they get great feedback from lawyers. At first, lawyers were upset about the requirement, but then they found that they enjoyed the learning experience, the user-friendly interface, and the free credits. So typical kind of reaction from being required to do something. But Illinois has one of the more nicer presentations because it's interactive e-learning. And so different from making you read text and fill out, questionnaires, you're actually in an e-learning environment in Illinois, and that might be lending to some of its positive feedback. When we spoke to Colorado also said that their experience has been positive. They said the fact that this resource was developed not simply by regulators, but by practicing lawyers was very helpful in outreaching the program. They said that the program includes many best practices. It is not simply a checklist of commands from the Colorado Rules of Professional Conduct, and that the program has received unsolicited positive feedback from their lawyer members who have undertaken the assessments. And they attribute a lot of the positive feedback, some of the comments, to the voluntary and the anonymous nature of the program. He finished by saying that he would stress that this is a resource that has been viewed positively by the legal community and is one of the several proactive educational programs our office supports and is designed to help lawyers in navigating difficult practice. And let me just mention one thing that's lost about the self-assessment activity versus other MCLE or educational activities is that when it's personalized, when you're answering questions about what do I do when I do a conflicts check, do I check just the parties, or do I check the witnesses, or check the owners of the organizations involved, and you answer the questions honestly, a good self-assessment program will give you customized feedback with resources. And so if it's a self-assessment about trust accounting and you answer a lot of questions bad about reconciliation, a good self-assessment program will pump out resources that are geared to how to do a good reconciliation. So I think the jurisdictions who are doing good self-assessments are probably getting positive feedback, whether they're voluntary or mandatory, if the self-assessment is actually helping the lawyers to do better, informing them of gaps in their best practices and giving them resources to improve.
Thank you, Randy. And I should have turned to you right away. I didn't see you on for some reason. I'm so glad you're here, as I'm going to hop off. But Randy's the perfect person because Randy's office is in charge of developing the attorney self-assessment. And obviously he's done a lot of research. So with that, I'm sorry to hop off. I'm glad you're on, Randy. All right, bye.
Randy, can I ask that last state that you mentioned with the voluntary and anonymous that's getting positive feedback? Was
That's
that
Colorado.
Colorado?
And we have actually in Linda's materials, the first example in the attachments is the Colorado. And you see in the last column that they map the resources to the questions.
Yeah, so, and I totally agree with that. So a voluntary self-assessment, checklist, education program is a wonderful tool. And if it's interactive and provides feedback, I would definitely be in support of that.
Yeah, the one thing about the interactive and the e-learning side is because if you want to, attract lawyers to use this or paraprofessionals to use this, offering credit, whether it's low cost or free MCLE credit, is really the bait that you get to reel them in. If you just have a questionnaire, a survey, it's questionable whether the state bar should be offering credit for that experience. But if you pair it with education, it works.
Yeah, I really like the pairing it with education and providing credit.
Yeah, and it really satisfies consumer protection goals as well, because the paraprofessionals will remain up to date and on the rules on what they have to do.
So did we want to talk about other things besides the self-assessment? Because I think we also are in agreement on ethics hotline and toolkit. So I think there's room for us to move forward. I think the case review, last time we discussed it, I think there were some concerns, not only about burden, but privilege and other things. So again, I think at least I had some red flags. We discussed some red flags last time, if I recall.
Should we work off that table that was put up in the beginning, or because I had some questions about that? Should we work off of that? Yeah.
So this is the evaluation. Do you mean work off the slide for the proactive
Well,
regulation?
this actually, if you look in the recommendation column, it includes recommendations for program evaluation and for proactive regulation. So maybe we can look at that column and just point to the ones that are recommended for proactive regulation.
Right. I was gonna, if I can start, I was gonna comment on collecting information from clients. So case outcomes and client satisfaction. How do you plan to even do that? It's really hard to collect data from consumers.
And at this point, I actually would like to share the email from Kim because it touches on this.
Okay.
She talks about the timing of any questionnaire. And she said that one of their programs has to provide a report to the legislature. And what they found is that the timing of the questionnaire really impacts the response. So for example, surveys to consumers immediately following an arbitration meeting, prior to receiving the decision, the satisfaction that's reported about the process, the pre-decision surveys about the process that was undertaken is much, there's a higher level of satisfaction about how the staff was, about the staff, the arbitrator, the entire arbitration process. It's a very favorable reading prior to people receiving their decision. And if the decision went against against the client, it casts their whole evaluation, including things about how the process went, more negatively. So she just wanted to caution against that, and to at least, if there's a recommendation for client surveys, to consider the timing of when the surveys would go out.
Right, because often client satisfaction with the performance of the paraprofessional is the response has nothing to do with that. I mean, the paraprofessional could have done the best job possible, but hey, it's the judge that makes the decision. It's out of their hand, and they could have been ethical, they could have been informed and competent and all of that, but the satisfaction is still going to be done. So it's just not an accurate measure. We see that here too. And the other question I had was, so yes, the timing is very important, and the results are going to be, the answers are not going to be accurate reflection of what actually happened, and the measuring performance of the paraprofessional, but also access to the consumer. So when are you going to, when is the best, how are we going to access consumers? Because it's just, they're out there. It's really, are you going to ask for case names or client names from paraprofessionals and then reach out to them directly? Or is the paraprofessional supposed to provide the question? And even in that case, it's not mandatory. So, response levels will be very low. So how are we going to tackle these challenges to be able to get some quality data and sufficient number?
And that might be something that would be part of the program evaluation, where there could be a significant effort to contact the clients of the paraprofessionals, as opposed to as the proactive regulation, where, as you say, it might be challenging, although we might figure out a way to do that.
And is it, is release of the information going to be allowed by the paraprofessional? Is that going to be a question maybe put into the original intake, saying, do you agree that I release your information to the state bar for purpose of program evaluation? You see what I mean? And it's not easy.
Right.
As a client, maybe I don't want them to release my name to you.
One of the things that we talked about was requiring in the disclosures, or at some point, maybe it's at the time that the client that hires the paraprofessional, that they be provided with information about a link to a survey, so that then it would be the client taking the initiative to complete a survey. That could be one way to approach that in terms of both proactive regulation and program evaluation.
Not as a part of the 3 written instruments we approved the other day, right? The initial notice and the informed consent and the written agreement, right? Like a separate written document.
Right, there could be a separate written document, or they could, and I think this is one of the things that the state bar found. We initiated a program to do surveys of people who filed complaints, complaining witnesses, to find out their satisfaction with the complaint process.
Mhm.
And when we included that information in a letter that was sent to them at a different point in the case, even when there was a link in the letter, we really got almost no responses. When we changed instead to sending an email to the survey, so then there was a live link in the email, the response rate increased. So it could be that there could be a requirement that paraprofessionals provide send an email with a link to a survey. But again, it would be hard to know if they've actually done it.
Yeah, so again here, I am a big fan of client satisfaction surveys. I think they can be very useful. I do expect there'll be some aspect of that in the evaluation, but a mandatory client satisfaction that the results go to the bar. I think if we want to encourage people to do client satisfaction surveys or put it in the toolbox or be supportive, I think that would be great. But I think we need to know what the program evaluation is going to be doing. And it's not clear to me what the bar would do with that client survey information that they receive, or that it would be useful in any way. So I'm hesitant to mandate it as part of proactive regulation.
Linda, maybe I can just mention something about how the State Bar administers the Lawyer Referral Service Program. The Lawyer Referral Service Program does have an actual requirement that the Lawyer Referral Service Governing Committee must annually survey a random sample of at least 10% of the clients of the Lawyer Referral Service to determine client satisfaction with service and fees. And on the basis of the annual survey, make any operational changes it deems necessary. And as part of the annual renewal process, a Lawyer Referral Service has to submit an annual report. And one of the requirements for the annual report is to summarize the annual client survey and any operational changes that the annual client survey has prompted. And so that is something that is part of the minimum standards for certified lawyer referral service. And as long as it's incorporated with normal regulatory interactions with the licensee, like the annual renewal or an annual reporting function, I don't think it's too burdensome. There is an amount of trust the licensee going on, though, because I don't think we have a way of going behind the LRS program and finding out, did they really get 10% random sample, or are they just showing us the good responses? Or so there is a certain amount of that going on, but it is something that's actually required by the state bar rules.
I can vouch for the Bar Association of San Francisco. When I worked for the Lawyer Referral Service, we sent a survey to every client, and the responses, the analysis that we sent to the state bar was 100% accurate.
And Randy, there, when you're using the term the licensee and getting behind the licensee, you're actually talking about the LRS service. Is that
the
right?
LRS service, yes.
Yeah, so I think it would be great. I think it's being proposed that there be a similar parallel LRS for paraprofessionals, or that paraprofessionals could be included in lawyer referral services. And to the extent lawyer referral services are doing that, again, I'm fully supportive. I just, for having a mandatory for all licensees, and here we're talking about the paraprofessionals themselves, that is a voluntary thing. I think when attorneys join an LRS, it's sort of a benefit to them to getting clients, and then there's some burden associated with that. And I think something parallel for paraprofessionals would be perfectly appropriate.
I agree. I like the idea.
So you're saying you don't want to include any kind of a mandatory survey in the proactive regulation, but you do think it should potentially be included in it. Well, even though we're not making recommendations about program evaluation, you don't want to include it in the proactive regulation. Is that accurate?
Yeah, for me, I don't want to include a mandatory client survey in proactive regulation. I think it will be and should be part of the evaluation, and I think it could be and should be part of LRS for paraprofessionals.
I would only want it to be in proactive regulation if there is a, enough of analysis step by step to make sure that it results in, how can I say, discipline of bad actors, catching and disciplining bad actors out there. Because right now this area is unregulated, so there are a lot of bad actors. Consumers don't complain. I mean, even if we give them the resources and really egregious cases, a lot of people just, it's okay, they just walk away. So if we collect these surveys and if we want them to be included in proactive regulation and lead to discipline, will they really lead to discipline? Will we really get accurate surveys? Will we get a lot of surveys? I just want to hear how that's going to work. Maybe we're too at a stage where that kind of detailed information is not going to be available to even processed information.
Well, I think in terms of discipline, the complaints will be handled the same way that attorney complaints are, and part of the State Bar's education program to educate the public about this new license will be to educate people about the ability to file complaints. Just as we are making all kinds of efforts to educate people about the ability to make complaints against attorneys. We've had a very active presence on social media as well as in the standard media about, if you have a problem with an attorney, you can file a complaint. So I think that's really would be separate from the surveys.
Mm-hmm. Then I would agree that it has no place in proactive regulation.
Okay. So let me see. The next one is this doing a survey about affordability. So this is on this next one about affordability. And then this survey could be based on not client surveys, but a review. If we require paraprofessionals to do some sort of a regular reporting where they are required to report what they charge, perhaps provide information about the fee structure. This could be a survey of either clients or paraprofessionals.
So I would be in favor of the bar collecting information from licensees about what they charge. I think this is a big risk, but I just want to be careful that I don't think that in any way regulates the risk of affordability and overcharging. So I think I'm worried about how the bar thinking that they're proactively regulating in some way. But I do think since we're not regulating fees, that it could be useful to collect information.
Right. I have to agree that this is more program evaluation than regulation, especially because there are no fee caps. So it'd be good to know, what's the average rate being charged by paraprofessionals, perhaps based on the legal specialization and so on. But I just don't think it has a place in regulation or discipline.
Right, but I think
Right.
collecting the information may
It's
be
very helpful.
So I would be in favor of the State Bar collecting that and maybe a required collection. Again, I don't know if that's any different than what you're suggesting, Linda. I just worry about the characterization. I don't think that is any kind of meaningful proactive regulation, but it is information collection that I think I would support.
So then we're talking about requiring regular reporting by paraprofessionals about their practice. And if we're going as part of proactive regulation, as opposed to evaluation, or maybe in addition to evaluation. So if we're going to impose some kind of regular reporting, we should think about what other information we should be collected in regular reporting and how frequent that reporting should be.
Totally agree. And that it's not too burdensome, but I think it would be worth collecting this information. And there may be some other pieces of information, but I think that's very different than a mandatory self-assessment, for example.
I would want to collect information to determine if the objectives of creating the program are being met, affordability being one of them, increased access to justice being one of them.
That's a program evaluation issue.
Right.
That's not a proactive regulation. So,
No.
so if we're focusing now on how this would be done in terms of proactive regulation. So this is
Right.
really at the individual level rather than at the program level.
But I thought you said providing the information mandatory, right? That they have to turn in this information, right?
Right. And so
That's
right. But
practical.
again, so the question is from a proactive regulation standpoint, and again, this is at the level of the individual licensee.
Mhm.
What would we collect? How frequently would we collect it? Would we require them to report on every, like to send a copy of every retainer agreement, every contract? What kind of information would we want to collect? What would we want to for the licensees to provide, and how frequently?
Yeah, so I think the disconnect here is what I was trying to raise concerns about. I don't think this is technically proactive regulation, because I don't think what at least I have in mind would be lead to discipline or fixing the system. It would be collection of information. I do think there are other questions we should ask, like Fariba is suggesting, like what can we do to help you type questions. What do you need? What system do you think should be in place? Do you think the systems, so there could be some other questions, not burdensome questions, but just required questions on a short questionnaire. I would be totally in favor of that, but I hesitate to include that in this discussion of proactive regulation because I'm not sure technically that is. But I am concerned about the affordability. And so I would be in favor of a collection of information.
I would also be wanting to collect information about fees charged. However, because you don't collect the same information from attorneys, it's hard to evaluate it because we don't have fee caps, right? So one thing I would be looking for is, are they charging this similar fees as attorneys for that legal specialization? But we don't have information about attorneys and how much they charge. So, well, we have information about lawyer referral services, right? You guys collect that?
We don't have information about what people charge.
Not even in lawyer referral service programs?
No.
Okay.
Yeah.
Well, modest means panels, right? In different counties, if they have them, they do report that, right? I know.
They in the very few places, there are a number of places in modest means panels where there's a limit on how much attorneys can charge.
Yeah.
But they don't report. I don't believe, Randy,
Oh.
that the lawyer referral services report how much individual attorneys charge.
At best, I think we have information about where the lawyer referral service will reduce or waive the referral fee for the consumer to get to the attorney, but we're not collecting information from the panel attorneys as to what they're charging.
Okay. I wonder what the value of that information is if you can't compare it to something, right? If you collect information about how much the paraprofessional is charging, what do you do with that information?
Well, I think the bar should publish it, although probably anonymize it, so by county. But make it I think it's part of regulation and part of the public's transparency into what this new licensee is. Because I think at some point there probably is going to need to be a revisit of regulation of fees, in my opinion.
But again, that seems like that's part more of the regulation. I mean of the evaluation. So if we're going to require attorneys to report how much they charge, again, I'm just wondering, what's the vehicle? Are we going to, is that the only piece of information, and then, or do you have an idea of a vehicle by which we would collect information? Would we have standard reporting, like an annual report that attorneys have to file with information about how much they've charged each client, or their average hourly rates, or their per case rates?
Is the MCLE every 3 years reporting? Because it could be something that's attached to the MCLE, just a simple questionnaire online when you fill out your MCLE. And again, I would, although I would like accurate information, I would tend to try to make it simple, so we could just figure out what the right questions to ask about average hourly rates, or flat rates, or standard rates, or however you want to be able to process the information. But I think it could be made in a simple collection form.
Okay. So maybe when they with their annual licensing.
Yeah, exactly. Hopefully there'll be some checking where they're confirming they have the right bond, or they've completed whatever requirements, and just do something simple. And
Okay.
I do want to make sure it's not burdensome, but I think the information is worth collecting.
Okay. And then, and that would be used as part of the proactive regulation. In what way?
Well, I think the bar would be assessing whether this really is an affordable alternative to attorneys, county by county, and publicizing the information, although I would assume it needs to be anonymized.
Well, I'm struggling with this, and maybe Randy, you can chime in on this. To me, that seems like that's more of a program evaluation. If we're not doing anything with that information at the individual licensee level, it doesn't serve the function of proactive regulation. Am I wrong about that?
Well, I agree. That's what I was trying to explain, but I still think we should do it, even though we should not fool anybody to think that we're actively regulating it. We are collecting information about it. And whether you want, maybe we don't call it proactive regulation, we still recommend it, but we make clear that this is not what's traditionally understood to be proactive regulation, because the working group has recommended that there be no limitations on fees, but it's still something that we have decided is a risk factor that we want to monitor.
But providing the information is regulation, right? That's regulated, that you have to provide this information, whatever, every year with your, to keep your license, right? Am I?
It is a regulation that it's required, but it's not proactive regulation, in that the state bar is not using the information it collects to proactively address concerns.
So then, I'm just thinking about how we would present this. So would we present this as a new regulatory requirement, but not necessarily proactive regulation?
I mean, it doesn't matter to me. I think we can include it in our recommendations here, because this is where we're coming up with it, and we're the regulation subcommittee, but it might be worth a footnote or a note that says, this is not actively regulating affordability. This is collecting information so that there's information available about affordability.
Okay.
I think some of the people who voted for no fee cap said, the market will regulate itself. No regulation is needed. So this is one way to check if that is true or not.
Okay. So I don't want to go too fast, because maybe you disagree with some of these where there's a recommendation not to collect, or where we think it should be considered just program evaluation. So let me know when you're ready for me to move down on the screen.
I'm ready.
Reba?
I'm not sure if this is proactive regulation, but I still want to make sure you consider providing an easy way for consumers, not necessarily to file an official complaint, but to file an honest sort of review of a paraprofessional they used. So that if there is enough of those for a certain paraprofessional, a little red flag goes up, not for discipline, but to offer ways for the paraprofessional maybe to do a self-assessment, to say, what am I doing that is resulting in so many of these reports? It's not necessary, and then make clear to the consumer that this doesn't this is not the proper way to lodge a complaint, to start a disciplining process. This is just collecting you're just evaluating your paraprofessional's performance in your case. I just think I just want to, provide a way for consumers to do that. It's just not there now. Even when they have a really valid case, valid complaints, when the conduct has been egregious, they still don't, it's just too difficult for.
Right. And we actually, I think we consulted with OCTC on this, and the concern was that complaints, people tend to file complaints, negative complaints, like reviews tend to be more negative, and it's questionable how valuable that is. I think when people really have a concern that, I don't mean a complaint, I mean a review.
Right, and that's what I'm saying. You
Or a
don't pay
survey
attention.
response.
You don't pay attention to every review, but the programs out there, perhaps that you could raise a red flag when a certain paraprofessional receives, I don't know, 100 of these reviews in a certain time. It's a red flag. Sure, 1 or 2 people, 3 people, 10 people could do these reviews because they didn't get the result they want, and those reviews will not be accurate because there's nothing to do with the quality of work done. It's just because they didn't get the result they want. We just talked about that, right? But if a certain paraprofessional gets, so many of these, and maybe that's a legitimate red flag, and the state, well, you're just gonna look into it, not even to reach out to provide educational tools and let the paraprofessional know, hey, this is happening.
So you think we should have a requirement that paraprofessionals provide a link to a survey that's separate from filing a complaint?
Let's say yes. Let's see how that goes. It would be great to be part of those written instruments we provide in the very beginning of the relationship.
Yeah, so this goes back to the client surveys. I think I oppose a mandatory client survey that goes to the bar that could be used for discipline. Again, I'm in favor of that being used in evaluation. I think the marketplace has that. So hopefully Yelp reviews, if people are providing poor services and getting bad reviews, maybe they won't get a lot of continued business, but I don't think proactive regulation of required client surveys at this point makes sense for the reasons we discussed.
Right. And again, the question of how would we know that, how would the state bar be able to monitor that the link to the survey is being provided?
Oh, I'm sure there are very smart programmers out there that could come up with something that would just, you wouldn't even actively monitor it. Maybe I'm not high tech enough to know that that's impossible.
No,
but
that's not what I mean. How would we know in every instance that the paraprofessional provided every client with a link to the survey?
I mean, how
it's going to be a regulatory requirement?
It's like with everything else. How would you know that the paraprofessional provided that pre-service notice? How would you know if they provided the informed consent? I guess you wouldn't know until a formal complaint is filed and you have to go, and the paraprofessional would have to provide all those documentation. You wouldn't know. It's an honor system. Am I right? You wouldn't know.
Mm-hmm. So it sounds like we have sort of this split recommendation about providing that. And then I just want to also go back to Kim's email where she just had some concerns about the timing of any client surveys.
Mhm.
So, so Fariba, you want to recommend that paraprofessionals be required to provide a link to a survey, and that survey was somehow, the survey was monitored by the state bar, and the state bar would have some way of analyzing how many complaints. So,
Well,
Where is
survey,
the-
well, wait a minute. Survey is a neutral word, right? It would be a survey, not just for negative, right?
right, yes,
Right?
yes.
So I suppose I'm interested. I mean, it's great that there's wonderful paraprofessionals out there. I'm interested in reaching out to those that are garnering a lot of negative comments. By looking at the comments, looking at the timing, are they really complaining about the performance and the competence? Or are they just upset because the judge decided against them? You see, because there's an easy way to ask that question. We do that here too. Ask the question to determine that, right? I'm not suggesting a general survey. I don't want to call it a complaint hotline because it's not really a complaint, but I want to, be able to identify those paraprofessionals who perhaps are not performing the way they should, and for two reasons. One, to catch the real bad actors, and two, to really provide education, more education, recognize that they need more education, and help them recognize that, and just provide resources to stop really serious harm being done as they go on with doing conducting business the way they are.
Okay, so, but I just want to make sure I'm capturing this accurately.
And the reason I say that is because these people that we see now with horrible paperwork, when they don't go back to the paralegal and say that paralegal keeps doing it, keeps doing the same work. They don't know because people don't go back. They just move on. And I don't blame them.
I understand that. I just want,
Yeah.
I would just want to clarify, because I'm going to have to draft this.
Yeah, I know.
Is that you want to require paraprofessionals to provide a link to a survey
Mhm.
that's separate from where they would file a complaint, and that the state bar would monitor these, and when a significant amount of negative feedback was received about the paraprofessional, the state bar would then use that information to proactively contact the paraprofessional and let them know, hey, we're getting a lot of negative feedback about your services. We'd like to suggest X, Y, and Z.
Right.
Is
And
that-
maybe this could be part of the pilot. And maybe it doesn't work. Maybe it goes down in flames. Nobody filed anything, or no clients took in any surveys, but
Okay.
it may be a very valuable tool.
And Amos, you're opposed to this recommendation.
Correct.
Okay. Right. So then should I move on?
Sure.
So this page doesn't identify any proactive regulation, that doesn't have any that the staff identified, but I'll give you a chance to review this, see if you disagree.
I agree. For paraprofessional training, and this might also relate to toolboxes and resources. Again, if we're collecting information directly from paraprofessionals, there might be just a suggestion box type question. But do you have recommendations for additional trainings or resources that could help you provide, competent services? Because that's what we're really trying to regulate. So some way to get that feedback.
So this is again in program evaluation.
No. So I'm saying if we're collecting information, for example, about affordability, and there's some sort of
Oh, I see.
questions, I think that's another question we should ask, which really relates to this efficiency in paraprofessional training or adequacy in training is to collect that information.
So you're recommending that so this is neither for proactive regulation or program evaluation. This is just a suggestion you have about providing paraprofessionals with an opportunity to give feedback.
Okay.
Is
Again,
that
I
correct?
don't mind so much of how it's characterized, whether it's proactive regulation or not, but I think the point of proactive regulation and why we are discussing it now is to create regulations that will potentially increase or support competence of paraprofessionals, and that's what I'm trying to do. So I don't know technically if academically we would characterize it as proactive regulation, but I think it is falling within our proactive regulation bucket. We are asking for feedback from paraprofessionals about what additional resources could be useful. Just like as Randy described the Colorado self-assessment as something being created by feedback and input from attorneys, this would be the potential method that we could proactively create new resources to support competence.
Okay. Reba, do you have anything to add on this page? All right. So that, yeah, so this is the last of it. So
But there were some other things, sorry to interrupt, Linda, but I think on the prior slide, so the ones where there were a few different types of proactive regulation, so not this chart, but the prior slide.
From the PowerPoint?
Right, the PowerPoint, right.
Let me bring that up again.
That we also agreed on.
Hold on a second. So we've got the MCLE toolkits.
So that's something but we both agree on, right?
Yes.
Second.
Yeah, we talked about that. I think we landed on voluntary self-assessment. That's educational and MCLE credit. Ethics hotline and online resource. I think we agree
Yeah, we
on.
just talked about it.
Yeah, I think we did not agree on this one because of the problems. Wasn't there another toolkit slide? Oh, it's part of MCLE. Sorry about that. Great. Do you think, I know we have other things to get to, but do you think we could open it up for brief public comment in case there's additional thoughts about this since we're somewhat brainstorming?
Sure.
I unfortunately have to log off, everyone. So
Okay.
have a great weekend.
Thanks. You
Thanks, Greg.
too. So if there's anyone from the public who wants to join this or add comments regarding proactive regulation, please raise your hand. Okay, I'm gonna have Angela Grijalva, and we'll allow for 3 minutes because we do have other topics that we need to cover during today's meeting. So go ahead, Angela.
Thank you so much for this opportunity to speak. I really appreciate the direction that we're going, and I appreciate that the hard wall where we're not this is, proactive versus, I guess a regulation in the sense that to penalize the paraprofessional and going to the perspective of helping them grow and develop, right? Because I think all professionals, regardless of whatever industry, especially new budding ones, we need feedback and we need constant development, which I have learned for my own business over the past 5-6 years now. And so I would say the survey that an active link survey sent by the State Bar, if the State Bar would be the agency to oversee this profession, and allow, it could be very simple, thumbs up, thumbs down. And if the participant wanted to provide more in-depth detail feedback, they would. But I can tell you, when trying to get feedback from my clients, I have to pin them down and ask them, what can I do better? How could I make this better for you, this experience? And what were the hardships? I mean, I actually have to pull, it's like pulling teeth to get that out of them because of the nature and stress of divorces and whatnot. And so, and also, I appreciate the feedback about the reviews because FYI, like right now, the pandemic, I've never had bad reviews. And for the first time, I'm getting bad reviews, but because of the stress that people are under. So if reviews are to be taken or surveys are to be taken into consideration, it shouldn't be from a penalizing perspective. It should be given with a grain of salt in light and the understanding that, you know, we're dealing with people in crisis. So just that little bit. Thank you so much.
Thank you.
Thank you. Is there anyone else who wanted to make a comment? I don't see any other hands. Okay. So
So do you have enough from us to write it up?
I think so.
Great.
The next topic was the licensee names. And I don't have a slideshow for that, but I can, I hope you had a chance to review the memo that I prepared. And I also have some feedback from sorry, I'm trying to manage too many things.
Linda, this is Randy. I'm going to drop off. I was
Okay, thanks.
here for Ethics Hotline and self-assessment.
Thanks,
Great.
Randy.
Thank you so much.
Guys. Bye-bye.
So let me just, Kim provided some feedback on the licensee name. So as we discussed the last meeting, the idea that we had was that that several names are going to be included in the recommendation as opposed to just one name, and that the Board of Trustees will ultimately decide on a name. But your group expressed a lot of interest in providing input, so we sent it to these two different professional translation agencies, provided their feedback. We also shared it with Elizabeth Olvera to get her input, and I summarized all that information and put it into a memo with some recommendations ultimately, and to go to the board. And we did want to get your input on the names, the recommendations. And so Kim provided some feedback, and you know, I would have sent this earlier, but I need to post it to the agenda. I didn't get it in time to go through. We have to go through a whole process to make anything we post ADA compliant. And so since we just got this yesterday, I'm just going to share with you what she said. She said that she didn't think that we should include the term advisor in the title, because she said we go to advisors to gather advice, and that makes me think that the individuals don't have the authority to provide actual services. If I was someone looking for legal representation, I don't think I would use them if they were just an advisor. So these individuals would be able to represent the client, which is very different from giving advice. So she thinks it'd be better to think of something about an advanced practice paralegal. So, and she said from she liked this limited license legal practitioner. as an option. And did you want me to bring up the memo with the recommendations? Would that be helpful? To bring that up on the screen?
Maybe for people in attendance, I did have a chance to review it.
Okay, let me just go ahead and bring that up. So, and I'm going to start at the end. We talk about
So
I
Linda,
can't see what you're seeing. Can you see this page 3 of this memo with the staff recommendations?
yes. So Linda, is it my understanding that after further review and after the prior feedback, these are the 3 that staff is recommending and that just Patru plans on including in the report, or are there other named in consideration, and are we being asked for other names or just to comment on these?
Well, you're free to provide whatever feedback and comment you'd like to. So the names that were sent to the translators, well, that's
I think it's on Exhibit A.
right. And these were based on a combination of what rose to the top in the 2 surveys, as well as feedback that came from the full working group during the discussions. And I think especially Amos, you wanted to use these terms limited legal and then append something to the end. So we did include all of those and ask for translations. This translation is the one that, as I detailed in the memo, this was the preliminary translation, doesn't reflect what we got back following a more in-depth discussion. And I'm gonna go ahead and
But
share.
the Spanish interpretation has the word abogado in it.
Right, that's what I'm just saying. So that initial translation, I saw that there were problems with it. So I called up and actually had a conversation with someone. And this is sort of the new improved translation from the same service from Language Line, but it doesn't include the word abogado. I think that the instructions that went to Language Line requesting the translation weren't as clear as they could have been.
So I'm happy to provide my feedback. I do have some strong opinions. Again, sorry to do this, but is it possible to open this up for brief comment? Because I think this is a different topic.
Yes. Yes. So if there are any attendees who want to comment on the topic of the licensee name, go ahead and raise your hand. We can.
And do you mind going back to page 3 that has the 3 proposed names? Sorry to do that to you, Linda.
That's fine. And I don't see, nobody is raising their hand.
All right, so I'm happy to jump in. Here's how I feel about it. And Linda, let me know if you want this in writing. I'm happy to shoot an email. But of these 3, I like limited legal advisor. The first one, the best. I think it is acceptable. I do like the word limited, as you noted. Legal is questionable. I don't think legal is required, and the translation to abogado is very concerning. But with limited and advisor, I think it works. So I support that one. I also am okay with the third one, limited license legal practitioner. I think it's a little wordy, but I think it includes the limited practitioner is fine as well. So I think that's fine. I have serious concerns about the middle one, licensed legal advisor, mainly because it doesn't include limited, and especially with the risk that it could be translated as abogado or licensed without limitation. I think there's serious concerns about misinterpretation and misleading and problematic in terms of what we're trying to avoid. So the reason why the regulation subcommittee, or at least my voice and wanting to weigh in on this, is because when we were looking at advertising and we were looking at program name, we think the name can be misleading and could lead to bad or disastrous results. And we should be careful, especially in the translation. And so licensed legal advisor, I think is not good for those reasons. And just to follow up on Kim's comment about using practitioner instead of advisor, I would be fine with that too. So limited legal practitioner or paralegal practitioner, I think you said Kim recommended. I think those could be fine as well.
If I have to choose from these three, I would just go with the third one. I don't like the word advisor in the title at all. Originally, I wanted something that had non-attorney in it. So non-attorney legal practitioner, to make it clear they're not an attorney. Frankly, people are going to say, what is that? And they're going to, I'm just a paralegal, I can do more, because there's going to be this description of what the person is and does. But if really these are our choices, I would go with the third one only.
So we're not picking one choice. We're going to provide several choices in the recommendation to the board. So we're not landing on one choice here. We wanted your input on the choices that are provided here. So if we wanted to say limited license or limited legal practitioner, perhaps.
Mm-hmm.
Right?
What limited, you want to take out the word license? Or did you say limited license?
Well, I'm just saying limited legal practitioner or limited license legal practitioner.
Right. Of these three, I would only support the third one. And did you say it's not too late to put in another suggestion, or it is? Because, I mean, I don't even know, I mean, at that meeting, one of our meetings, I did bring that up as a suggestion, non-attorney legal practitioner. I don't know if that was even considered, was it put forward to Transcend or Elizabeth Alvera to see how it would be translated?
That actually didn't get included in what was sent to Transcend, but we could still do that.
I don't want to slow down the process. It's already too late, don't mind, but if you guys going to go back to them, I was wondering if having non-attorney in the title, would that translate well?
Yeah, I mean, I think where we are is we can suggest it, right? So if that's your suggestion, Friba, we're just making suggestions. This is like, I'm happy to suggest, as you say, Linda, limited legal practitioner as a combination to address this. I agree, non-attorney could be a solution instead of limited as well.
Okay, and the feedback we got from both Language Line and Transcend is that we try to head off, even though people are going to do their own translation, we try to head that off so that as soon as we start publicizing this, the publication goes out in multiple languages. So we put forth the title in Spanish, in all of the other languages at the time we start publicizing the program.
Okay.
And hopefully that will minimize any confusion.
Yeah.
I think that's fine, but I think people are going to translate as they translate. We can't control that. And so if we could avoid using, that's another reason why I think including something like limited is so important, because that needs, whoever's translating needs to translate that in some way. It's part of the name. And without that, especially if people are translating with abogado,
right?
And I think the problems are definitely foreseeable. And I assume whatever the list of names, if it's 1, 2, 3, 5, whatever is being compiled, will go out for public comment, right? Because I think it will be important to get legal services and broader public comment before the board decides.
Yeah.
Right. Everything, the whole report is going to go out for public comment. All of the recommendations, the rules, everything is going to go out for public comment. So you don't need to be concerned about that. So that will happen. So I think that's fine, and I can take that feedback and back to Leah and Justice Petru to see what they want to include, and we can certainly go back to the translation agencies and get their suggested translations for non-attorney legal practitioner. And I think the last item we have for today is Brady wanted to bring forward some additional issues about the potential legislative changes. You're muted, Brady.
Let me share my screen. So these are two sort of borderline, whether they're policy issues or not. So you may or may not want to make a recommendation on them, and I will pull them up. There's just two. How do I have to share screen first? So the first was one that actually Stephen Fleischman had mentioned, and this is Civil Code 1714.10. It deals with attorney with allegations of civil conspiracy against attorney based on the attorney's representation of a client and arising from an attempt to contest or compromise a claim or dispute. And so when a plaintiff brings such a claim against an attorney, there's a pre-filing requirement, and essentially they're not allowed to file such a complaint unless they've made a showing with a verified complaint and affidavits, et cetera, that they have a reasonable probability of prevailing. So this is, intended to prevent baseless civil conspiracy suits against attorneys based on their representation of clients. It is protective of attorneys in that way. So one might argue, based on the approach we've taken to other issues, that the same rules should apply to claims against paraprofessionals based on their representation. On the other hand, given the limited scope of what paraprofessionals practice would be, these will probably be somewhat rare or less likely. So there are several options. We could just identify this, as we will, a number of statutes for the legislature as one they might want to change, or we could make a recommendation one way or the other to either apply this to claims against paraprofessionals in the same manner, or not. Not doing so, of course, would make it easier for people to make civil conspiracy claims against attorneys. Although, of course, if they had a basis, then they would be able to pass the hurdle.
So Brady, forgive me, I'm not familiar with this section, but.
Nor was I.
So there is a possibility, I know it might be a minute possibility, but based on the legal specializations that this program is authorizing, there is a possibility that such a case could come up?
Right, and there's this is intended to go after baseless claims. So given that this is a baseless claim and intended to catch baseless claims, somebody could always make a baseless claim against a paraprofessional for doing anything for their client, and this could apply.
Yeah. So my position is that if there's even a possibility that this could come up for paraprofessionals, to leave them in as it suggests to be considered.
Right, and there's no real, that I can see, policy reason not to, other than we have always taken special care to be protective from a public policy perspective. Yet again, this is not designed to weed out claims with a basis. One could argue that and again, this isn't the client bringing the claim, so this is somebody that the paraprofessional has typically gone up against. One could argue that if they were a person of limited means who were representing themselves, this is a procedural difficulty. But again, when we look at who our paraprofessionals are often going against, I guess not in the family, it could be indigent against indigent, but in some of the other practice areas, they're going to be representing the lesser means person against a more well-heeled defendant. So that's a lot of thought there, but
I thank you for bringing this to us. I agree with Fariba, maybe for different reasons, but I think we should just not take a position and just flag this. For me as a litigator, a pre-filing requirement of showing the probability of prevailing seems extraordinary. It seems like a very high, unusual
like an
barrier.
anti-SLAPP kind of standard.
Yeah, exactly. And so I'm actually surprised about this, but I don't have enough experience to know whether there's a policy reason to have a different rule for paraprofessionals. So I think we should just flag this.
Okay, and Friba, was that what you were saying, or were you more, if we should make a recommendation, hey, change this?
No, I wasn't
Okay.
asking to make a recommendation. I just
Okay.
think it should be on the list.
Okay. And then the second one, excuse me, was this came up actually from you, Amos, at the last meeting, I think, that whether we had made a recommendation to an affirmative recommendation that running and capping should also be covered by statute in addition to Rule 7.4D. We had not. So the question here, and judging from the discussion, I think the working group would be amenable to affirmatively saying, hey, just like for attorneys, running and capping for paraprofessionals should be statutorily barred, even though we've also addressed it in the code.
Yes, I think so.
Everyone agree? That's all I've got.
So Brady, the one that I thought you were going to say that I raised at the meeting was the ability to void a contract where there's no written agreement. So the attorneys have the Business and Professions Code, I think it's 6147 and 6148. And we talked at the meeting about making sure it was on your list that the remedy of, the agreement being voidable is not something that we could include in the rules of professional conduct in 1.5.
That makes sense.
So we do want to, or at least my recommendation is that we recommend that there be a statute that would allow for the voidability of any agreement. That's.
Let me stop my sharing. Let me see. This was not part of the work that I did myself, so I don't know.
Hi, Kim. Glad you were able to join us.
Hi, Linda. Sorry I'm late. Too many meetings this week.
Yeah.
Was that 6147, did you say?
Yeah, 6147 and 6148 is the attorney rule. And what we did was we incorporated a rule of professional conduct, 1.5.2, with parallel requirements, but the remedy would just be discipline. Whereas if there's a statute, it could be voidability of the contract.
So that was actually, and is that just for Micra? Because I've got the table that was submitted has that lumped in with 60. Let me share this with you.
Yeah, I mean, it's part of the State Bar Act, so there might be some other provisions, but I think.
So
6146 through.
And
So
this was from Randy. So it's 60. Let's take a look at the actual statute. Am I still? Are you seeing just the table, or?
we see the table.
Okay, I need to do a new share then, I guess. Now you can see Westlaw.
Yes. There it's C.
Yeah. So, gotcha that it must be in writing.
There's
Okay.
slightly different. There's slightly different requirements for attorneys. So they have $1,000 minimum requirement. Greg's the expert on this stuff. And we had, of course, different mandatory disclosures in
So-
1.5,
so-
but the real issue is the remedy.
So basically, we'd want that remedy and what was the, I guess I could just find it, but the rule you mentioned,
1.5.2, written agreements.
1.5.2. So is to make sure that that remedy is also available for, and see, this is why it's good that we go through this several times and that we'll have public comment, because in the table, this got lumped in with the micro provision, which I think is 6146.
Right. And by the way, 6148 might also have, I think it's slightly different, but it might be worth
Yeah.
looking at a bit.
That's obvious.
Yeah, no, I guess it's just the,
So essentially, the recommendation would be to make sure that the remedy of voiding the contract is applicable to violations of 1.5.2.
exactly.
Okay, and is everyone in agreement on that? And then we can just put this in with the list of the other 7 where we're all, okay, excellent.
Great, thanks. And if we're done with that, since Kim has joined us, I just thought we have about 15 minutes left. I thought we could just briefly recap the earlier discussion and decisions about proactive regulation and the licensee name. So, and this is going to be really brief and not include the in-depth discussion just because of time limits, but what Amos and Fariba agreed to is that proactive regulation would include the MCLE and toolkits, a self-assessment that was voluntary, that would, and which would provide MCLE credit, that we would, I'm trying to now look at my notes, that in terms of a survey, there was disagreement. So Fariba thinks it's really important for us to require that paraprofessional to provide a link to a survey that clients could fill out, and this would be separate from filing a complaint, and that the state bar could monitor the feedback that was received through that survey and use it just as a way to see if there are any red flags where and if there was a trend towards a lot of complaints, to use that to, not for disciplinary purposes, but to contact the paraprofessional with resources and educational materials and to share that feedback. Although maybe for Reba, you thought it should potentially be, could trigger discipline? No, okay.
No, unless the client files the appropriate complaint and follows that procedure. This for me is an educational tool.
Right.
And fits in proactive regulation to
Right,
me.
right.
It's not proactive.
Right, and Amos, I think, was opposed to having this as a
Well, I
requirement.
think he's about to agree. I don't know. I changed his mind.
Yeah, no, I disagree with the mandatory client
Right.
satisfaction survey.
Right.
It go into detail. I don't know if Kim, you're on the fence, happy to discuss the merits of that back and forth.
No, I struggle with this one just because I don't want to confuse the public from filing a complaint. You know, if they send in something like that, they might think that's a complaint. As valuable as I think that information is in coming in, requiring something like that, they might think that they're filing a complaint. They're going to do that whether it's mandatory or not.
So just so you know, my recommendation includes that it'll be very clear that this will not result in discipline. This is not the complaint procedure. Here's a link to where, if you want to make a formal complaint, here's the link to that, to really make it clear what the purpose of this is.
Yeah.
I just think that, again, there was a lot of discussion. One of them is that what I see now in today in our office, and I've seen over and over, is there is, you know, people walk away with a lot of valuable information that could be used for the paraprofessional or the paralegal, sorry, who are sometimes good actors, but they just don't know what they don't know. And that paralegal or the, sorry, independent paralegal or legal document examiner continues to do same faulty work because they're not told, they're not given any feedback. So I think this may be a useful tool to create a new generation of paraprofessionals who are more apt to act competently and to do competent work. Did I sell it? Hey,
I think
stop
it's the
it.
mandating, the mandating is probably more the issue.
Just
Exactly.
mandating providing the
Yeah.
link, that's all.
So,
Yeah.
and I think, Kim, I totally agree. It's the mandating that's the problem. So I think client satisfaction surveys are wonderful tools. I would encourage people to use it. We could put it in the toolbox. We could explain what the benefits of it are, but the question is it mandatory and are the results going to the state bar is what I disagree with.
Yeah, I was thinking that same thing about them going to the state bar. That would be, because then they'd have to get the information back out. It seems like a large workload, but I love the idea of a survey that they'd have to do and get it somehow back to the paraprofessional. That I agree. That's a great tool for individuals, for anybody. That is right. And everything I've seen, those kind of surveys are so useful. I mean, even as managers, right? They're helpful.
I just do say paraprofessional providing that link voluntarily. That's what I'm trying to say, is that providing the link should be a part of the 3 written instruments that we've already decided they're going to have to get, right? This would be a 4th one.
Right, so I can just write that up about and reflect this sort of disagreement. The other things that were agreed to was that paraprofessionals would be required to provide information about the fees that they charge. And this wouldn't necessarily be used in proactive regulation, but as part of the regulatory requirements on an annual basis, say when they, so I guess it wouldn't be when they first register, but each subsequent year when they are renewing their license, this is information that would be provided through the state bar portal, so that we would have that information when it's time to do the evaluation. Do you have any thoughts on that?
No, I agree. I think that's one of the biggest things that's going to help us kind of see how helpful this program is.
Right. And then a final thing in terms of this regulation is to ask the paraprofessionals for feedback about what additional resources the state bar could provide, including asking if the training that they were required to take in order to be licensed is adequate, but whether there are any additional tools the state bar could provide. So I guess, and so would that be mandatory? I'm just wondering, because when you go in and you do there's the annual license renewal, and there are those questions, there's a questionnaire, and some of the stuff is mandatory and some of it is not mandatory. I'm just wondering if we're going to require people to answer those questions, or if this would fall into the voluntary providing feedback.
Yeah, and I don't think you can require people to make suggestions, but I think you could require people to fill out the questionnaire. So if they respond no suggestions, I think that's fine. But I think requiring people to at least get the question of whether or not they have suggestions is going to be helpful.
Okay. And did I miss anything? I think that was all.
You had toolkits as well?
MCLE and toolkits
Are the same? Okay.
Right. Well, yeah, the voluntary self-assessment, and then these, yeah.
Sorry, I was going to say the other thing that was on the list that I think we did not agree to move forward with the case reviews.
Right.
And then for self-assessment, we had a lot of discussion about it, and I think we ended on a voluntary with credit and maybe an interactive self-assessment. That could be kind of a good educational tool, is where we ended on that, I believe.
Okay.
Yeah, I would agree definitely on the case reviews. Not right now anyway, right? That'd be too much right off the bat.
Okay. All right, anything else?
for the names? You want to go over the?
Oh, the names, I'm sorry. Oh, so I shared, Kim, I shared the information you provided by email. I shared the information that you provided about the client surveys, but also about the licensee name. And so I think that there was agreement in terms of, you know, the names that sort of rose to the top where they had advisor. There was agreement that we would recommend that Amos and Fariba recommended swapping out practitioner for advisor. So I think the names, the suggestions from this subcommittee were limited legal practitioner and limited licensed legal practitioner. And then Fariba also wanted to come back to the idea of having the term non-attorney in place of legal, not in place of limited. So non-attorney legal practitioner. And so we can,
sorry to interrupt, but my recommendation is a little different than that. I actually think the limited legal advisor is my favorite of the
oh, okay.
But I also like the limited licensed legal practitioner or limited legal practitioner. I think those are fine. I do not like licensed legal advisor without the limited.
Right.
I think that one has significant problems. I think that would be problematic, especially with the translations. But limited legal advisor, limited licensed legal practitioner, limited legal practitioner. And I also suggested, based, I think, on your comment, Kim, something like a paralegal practitioner or something like that could be possible as well.
Yeah, I was just thinking when I looked at them again, when I was reading the memo, I was thinking, you know, we have like advanced practice X, right? And so I was just thinking these kind of are a step up from a paralegal, because now they can do all of this, they can represent you. So that's where my head went when I was thinking about it. Like, we haven't really talked about that or brought that up. So I was just thinking even like an advanced practice paralegal. But I just don't know how paralegals would feel about that, you know, but that is kind of what it is, right? It's the next step for them. Although others can fit into it, but I do still like the limited, something like that in there. That's always, I'm with you on that, Amos. I think limited needs to be somewhere in the wording.
Right. And to follow up on that, I think it's a very good point. That is also parallel with the medical practice. So you have doctors and nurses, and there is some confusion there about, you know, physician's assistants. It's actually nurse practitioners, ones that get to practice without supervision, and no confusion there with, you know, nurse practitioner
right.
versus a doctor or a physician. So I like that.
Mm-hmm. And paralegals, I think, as defined, have to be supervised by attorneys. It's legal document assistants, or
Right.
they call themselves independent paralegals, but there's no such thing, right?
Right. So we're creating a new term.
Yeah.
Paralegal practitioner, which would be defined as somebody who does not need that.
And what are you guys' thought on non-attorney? What was it? Legal? What did I say?
Non-attorney legal practitioner.
Right. To have the words non-attorney in the title.
Yeah, I haven't thought about that, but you're right. That would make it as clear as can be.
I agree.
Right?
Okay.
So in terms of what, are you, Linda, are you putting together a memo of our comments or no?
No, so this is not going to go back.
Got
The idea was not, this is not going to go back to the full working group. This feedback I'm going to share with Leah and Justice Petru, and we'll decide how to move forward on which ones we want to include in the report and recommendations.
Great. Thank you for that opportunity. I appreciate that.
Sure. Okay. Is there anything else? Okay, we can end like 3-4 minutes early. Thank you. Glad you were able to join us, Kim.
No, thank you. Glad I got done early.
We missed you. We missed you on Monday.
Oh, I know. It was just like every meeting, I'm like, come on, just get over early. And at one point, it was funny because I was just getting on. I jumped in right before just to see where everybody was. And Justice Petru was like, we're going to take a break and we'll meet back at 1 o'clock. And I'm like, okay, this was not meant to be today.
Okay, thank you.
All right, see you next
All
time.
right, take
Bye.
care. See you tomorrow.
Yes, tomorrow.
Oh, yeah, bye.
Bye.